What national legal precedences are there to the Florida consent decree?
That then sort of moves on after Lau. I think it's important. And I think it is, again, I'd like to emphasize and re-emphasize, in this country, programs were not, I mean, Lau, of course, is a good example of this. Programs were not developing without lawyers going into court. These evolved out of a civil rights background. Following the Lau case, there were a number of decisions, some of which were pure bilingual decisions, and some of which still guide the states that they were brought in. Texas being one, Colorado being another, or at least Denver being another place. But the key precedents for the Florida consent decree are sort of two strands. The first strand is what I would call a substantive strand, and it comes out of a case called Castañeda versus Pickard, decided by a U.S. Court of Appeals in the early 80s, in which the court basically said that all school districts, they sort of built upon Lau and said all school districts have a obligation to address two distinct needs of limited English proficient kids. And it's important because sometimes we forget that there are two distinct needs as the courts have articulated it. First is the need to be taught English, to be given the sort of skills necessary to function fully and completely in an all-English school system and in an English-speaking society. The second, which is sometimes forgotten, is the obligation to address the substantive needs of these kids while they're learning English, or at least addressing it at some stage or other, so that often school districts think that they can get away with, or all their exclusive obligation is to have an intensive ESOL program. That is not true under the precedents, that they must as well make the basic curriculum that other kids are getting accessible to them. And so this Castañeda case said basically that there is two needs that these kids have, and school districts and states must address these. It really came out of a given school district, a small school district in South Texas, the Raymondville School District. But beyond the fact that there are two needs, the court went further, and it said that there are essentially four obligations that have to be met in serving each of these needs. First is that there's an obligation to develop a pedagogically sound approach or theory for addressing each need. And if you're operating without an educationally sound approach, then you're in violation of the law. The court did go some way to say that it's not the role of judges to judge between sound approaches, but nonetheless there needs to be an articulated pedagogically sound approach for what you're doing. Secondly, it is not enough, the court said, to have a theory that is pedagogically sound. You've got to put your money where your mouth is, essentially. It's great to have a theory, but if you don't do anything with it, you're violating these kids' rights as well. And the Castañeda case and subsequently the Denver case pretty much, it didn't exhaustively deal with that, but it clearly said that one of the key components in sort of having adequate resources is having teachers who are trained to deliver, and that's a crucial function, a crucial obligation on the part of school districts. Resources include materials, all the things you need to carry out an effective program addressing both of these needs. The third obligation that the court said was required recognizing that no pedagogical theory absolutely explains everything, is going to work absolutely unequivocally for every kid, says that you've got to have an assessment system that reasonably tells you whether you're doing what you ought to be doing. And fourth, what the court said is that if you don't, or implied, the fourth is clearly implied, and I don't think anyone would quibble with it. So if in fact kids are not succeeding, you've got to adjust. You've got to evaluate your program and look at your theory again. You've got to look at your resources again. You've got to do something about it. You can't just sit on your hands and say, well, guess that theory didn't work. Yep, okay, tough luck. You can't do that. You've got to adjust your program. That's one strand. That's what I'll call the substantive strand. The non-substantive strand is that undergirds the Florida consent decree, is the fact that that states have obligations as well as school districts. And this again, and it's important to remember our roots in the African American and Chicano civil rights movement. But this comes out of a range of cases that were brought in the 60s against southern states that basically said that looking at the George Wallaces of this world, the Claude Kirks in this state of the world, who basically said, we're not going to let school districts do what's right. And what the courts have said is that that education in most states, indeed there's no state that I know of that in which there's any dissent, is basically a state function. And school districts, as important as they are and as independent as they are in many ways, ultimately are agents of the state. So that the state itself has got to not deliver programs necessarily, but it's got to set the basic standards and monitor to make certain that those standards are lived up to. And so it is those two that allowed us to come into Florida, and in looking at Florida, it was clear that there were almost no state policies and very few kids being served by school districts. And we're talking about the late 80s, beginning of the 90s. There just was no state policy, so that when we got ready to file suit, the state consulted their lawyers, immediately realized that they were vulnerable, and that then led to discussions that and negotiations that evolved into what we know of as the LULAC or META decree.